We have looked through all the remedies. Now we are looking into the reimbursement of promotional expense. At common law, promoter has no right to receive remuneration or seek reimbursement for any expenses incurred while carrying out promotional activity. However, there's a case, Kepung Prospecting Limited and Smith, where promoter can enforce this promise provided he or she has provided valuable consideration for that promise, because in Malaysia, past service providing to an existing company constitute a valid consideration in under the Malaysian law. Okay, we have looked through fiduciary duties, the breach, the remedies, and the reimbursement. Now we are looking into pre-incorporation contracts. Pre-incorporation contracts. What are those? Okay. Now, at common law, basically, when a company does not exist, you cannot enter into any contract with such companies. You can see in the case of Newborn and Solid. In fact, the case of Kerner and Baxter also shown that a company is incapable of ratifying a pre-registration contract. Even they try to ratify it after registered. So at common law, you cannot do so. Okay. So these two decisions, Newborn and Kerner Baxter, are common law decision as far as pre-incorporation contract is concerned. Now, what about the statutory provisions? Under the Companies Act 2016, Section 65 provides that any contract or transaction made by or on behalf of a company when the company was not formed. So basically, the person purporting to act for the company or agent for it, so in this case, promoter, he will be personally liable on the contract or transaction. Okay. Now, Section 65, subsection 2, stated that notwithstanding subsection 1, a contract or transaction entered into may be ratified after its incorporation, and the company shall be bound by the contract or transaction as if the company had been in existence at the date of the contract or transaction and had been a party to the contract. So, let me just make it clear here. Section 65, subsection 1 says, okay, any contract entered into by the promoter is personally liable. Okay. Now, however, Section 65, subsection 2 says, okay, when the contract has been ratified after the company is incorporated, the company is bound by the contract. Okay, the company is bound by the contract made by that particular promoter. So there's a condition there that after incorporation, the contract must be ratified. Okay, and what is the effects of the ratification? So the company will be bound. But how do you ratify a contract? Okay, Companies Act 2016 does not mention method of ratification. Perhaps we can look into the case of Ahmad Saleh and Rawang Hill Resorts, Sdn Bhd, whereby you can ratify a contract via board resolution. So during the meeting, the board can adopt those pre-incorporation contract. So once it's adopted, it's confirmed that the company is bound by such contract. Okay. Now there are also other cases such as Chang Yu On and CS Key Development, which says that when there was a pre-incorporation contract, okay, ratification can be made by conduct. Okay. Now, in this case, Justice Siti Norma Yaakob stated that ratification of a contract need not be evidence in writing. It can be inferred by conduct. So basically, even if there was no board resolution, but it can also be by ratification. I personally feel that when we talk about ratification by conduct, you really have to look into the case itself, whether there was a clear and proper conduct that actually ratifies such contract. Okay. Now, what about the liability of the promoter? Okay, when we talk about liability, we talk about section 65. So we talk about he is personally liable. Now, basically, there's a question mark here. When a person is personally liable, what if he tried to exclude his liability? Okay, Companies Act 2016 is silent as to whether promoter can exclude liability. However, there's common law which suggests that promoter must use clear words to exclude liability. You can see in the case of Phonogram Limited and Lane, whereby the court says that clear words are required before personal liability is executed. There is no clear-cut rule on this. Some authors says that despite the common law cases which allows clear words to be used as exclusion of liability, but Companies Act 2016 prevails. There is no such case which support that particular argument by some authors. Okay, that's all about promoter and pre-incorporation contract. I would suggest classes, can you look through at page 41 for the questions. Can you please do both questions, Alex, Bill and Charlie, and the second one on Hartana Mewah Sdn Bhd. We're going to discuss those cases during tutorial. Okay, that's all for this chapter. We'll continue with some other chapter next time. Thank you very much. Assalamualaikum.